today. Real quick, I just want to talk about our good buddy Lori Vallow dragging us right back into court this coming Friday, April 17th. How did we get there? Well, if you remember, just a couple weeks ago on March 24th, Mr. Means did file another motion for yet another bond reduction, and Judge Mallard has decided to let that go to oral arguments. So we're going to talk about that for a few minutes, talk about everything that's going on around that. Not only is it just another bond reduction hearing, but now it's drama-filled because of the social distancing measures that are being taken in the jail. In addition to that mess going on, we're now getting word that the Attorney General is now getting involved. Things are popping off left and right around Lori and Chad these days, and I cannot wait for the fireworks to really kick off. But before we get started, welcome back to my channel. If you are new here, welcome. It is great to meet you. I definitely invite you to go ahead and hit that subscribe button. I'm very proud of the community that we're building here at this channel, and I would love for you to be part of it. With all that out of the way, let's go ahead and start reading some documents. Now, if you remember back on the 24th when Means originally filed for this bail reduction hearing, he stated that new facts had come to light. That's why they were requesting the hearing. Now, on April 2nd, he amended that original motion to read as follows. Lori Vallow, by and through her attorney of record, Mark Means, hereby declare in support of her motion for an amended motion for bond reduction as follows. Attorney Mark Means, being first duly sworn upon oath, deposes, declares, and says as follows. I am the attorney of record for Miss Lori Vallow. That on or about the 23rd of March, 2020, I filed with this court her declared motion for bond reduction. To date, no response or objection has been filed with the court, and despite requests for an oral in-court hearing on the above motion, no notice of availability of the court to hear such has been provided. That on or about March 16th, my office received approximately 1,600 pages of documents, records, as well as approximately 14.5 gigabytes of video, photographs, electronic production, and the like from the Madison County Prosecutor's Office. It is anticipated that future production of documents, records, tangible and intangible records will be produced to the defendant as acquired by the prosecution, totaling over 200 gigabytes / 10,000 plus pages of tangible records. That on or about March 30th, I traveled to the Madison County Female Detention Center to meet with my client in preparation for the forthcoming preliminary hearing and to review said documents and records. That upon arriving at the detention center, I was required, with no attorney-client option, to the sole option of communicating with my client in the public visitor meeting room, wall of glass between attorney and client, over a recorded telephone line, upon which my client was required to enter her inmate number for charges and consent to recording of said phone call prior to connection of the telephone lines. In addition, I was told that the only way that my client could review documents was to pass possibly sensitive information by and through a detention center officer from the public, my side of the room, through the multiple security doors to the inmate on Lori's side, all of which would be out of sight of the attorney and client. This procedure is unreasonable and in direct violation of the regulations, law, and Constitution of the State of Ohio and the United States of America. This detention center procedure and its unlawful restrictions have made it impossible to prepare for said hearings, to communicate with my client in a confident / privileged manner, and to simply review productions of documents and records with my client to assist in her defense of the pending charges and criminal complaint. These unlawful restrictions, as well as no hearing allowed today on the previously filed motion to reduce bond, are in violation of my client's basic due process rights, specifically but not limited to her rights to effective assistance of counsel, Idaho Rules of Criminal Procedure, Constitution of the State of Idaho, attorney-client privilege, Code of Federal Regulations, Title 28, Judicial Administration, as well as violations of the Constitution of the United States, included but not limited to the 5th, 6th, 8th, and 9th Amendment. Again, we respectfully request oral argument on this motion before Honorable Judge Mallard. I mean, so Mr. Means clearly thinks that he would be the only attorney on the entire planet right now going through these struggles. I'm willing to bet that most attorneys with clients behind bars are facing similar hurdles right now, all over the United States and frankly, probably all around the globe. I don't understand why he thinks it's just him. They're being singled out, and oh my gosh, she is now, yet again, the victim. He's basically stomping his feet and throwing a fit like a toddler, as if he's the only one dealing with this problem. His whole tone just frustrated me. And not only did it frustrate me, and I'm sure most of you, but it also got under the skin of prosecuting attorney Rob Wood. So Rob Wood fired back at Mr. Means with this. The state of Idaho, by and through the Madison County Prosecuting Attorney's Office, and hereby objects to the defendant's declared motion for bond reduction on the following grounds. 1. The defendant asked for her bail to be lowered to $10,000 or in the alternative to $50,000 on March 6. Since that time, the defendant disqualified the sitting judge on the case. It has been less than 1 month since the court reduced the defendant's bail to $1 million, and it appears to be an abuse of the court rules for the defendant to disqualify the judge on the case and then to request the same or similar relief so soon thereafter. The defendant has yet to comply with the valid court order to produce her children in the related child protection action. This court should make obedience to said order or show of good cause for why the defendant cannot obey said order, a condition for any further bail reduction. In the defendant's support of defendant's amended motion for bail bond reduction, the defendant describes the large volume of received and anticipated discovery and the difficulty in providing the defendant with that discovery. It is important to note that the reason for the current visitation restrictions currently in place at the Madison County Jail are a response to the recent pandemic outbreak. The safety of both inmates and employees is of the utmost importance to Madison County, the Sheriff's Department, and the Prosecutor's Office. Upon receipt of the defendant's amended motion, the state has discussed visitation protocols with the Madison County Jail. The state has been informed that what the defendant has called the public visitor room is no longer open to the public and that all public visitation is currently done electronically. What was the public visitation center is now being used for attorneys to visit their clients in a safe manner, which does not allow for the spread of the pandemic. In regards to the defendant's claim that the attorney's visitation being recorded, the state has learned that one conversation between the defendant and the attorney was accidentally recorded. The jail promptly deleted the recording of that conversation and has placed a block on all recordings in the current attorney-client visiting area to preclude any other accidental recordings. The state takes the rights of the defendant to receive and review discovery very seriously. As such, the state has visited with the jail and believes that there are options to provide the defendant with adequate access to the discovery, which the state will discuss at a hearing. So Rob Wood's like, yeah, I get you. I see that you're mad. But guess what? So is everybody else. Not like you're sitting next to Joe Blow and his grandma over in the corner having visitation while you're trying to talk to your client. Absolutely not. This space that was once the visitation room is now used specifically for client attorney meetings. Now, the state did admit to accidentally recording that phone call, and they said that there's been steps taken to prevent that from happening in the future. I mean, clearly nobody has expected what's going on in the world to be going on, and everybody's being dealt a learning curve with every aspect of every business. Another thing that Rob Wood did not hold back on was like, listen, we just did this a month ago. Like, we just did this on March 6th. He reduced it to $1 million, and then they said, nope, we want Edens out. They get him out, and then poof, we're asking for the same thing again. I mean, he made it very clear in his opinion that Lori and her defense team are abusing the system, and that's not okay. I don't know if he's drinking Lori's Kool-Aid or what exactly is going on, but this guy is just making an ass of himself, and I cannot for the life of me wrap my head around it. On April 9th of 2020, Judge Mallard did say that, yep, we'll go ahead and take this to oral arguments, and that is scheduled for Friday, April 17th at 2 p.m. local time to Rexburg, Idaho. Now, for me, that is 3 p.m. Central Time. At this time, I don't know if we'll get a live feed of this or if we'll get any footage immediately afterwards or how exactly all of this is going to go down. But what we can go ahead and do is plan to be live on this channel, and we'll discuss it while we wait, or if we're lucky, we'll be able to watch it or listen in together. Now, if you think back to March when Judge Edens did recuse himself, the hearing in which that was discussed took place via telephone conference. And that at that time, that was because of a scheduling issue. Now, it is likely that on Friday, we're going to see something very similar, and not because of a scheduling issue, but because of the current safety measures in place to protect everyone. Now, when Judge Edens recused himself, we did get a video feed right after the hearing had concluded. However, we did not get a live feed. So we'll just have to kind of, like I said, play it by ear and see what goes down. See if we get any word between now and Friday on what to expect. It's very likely we're going to see another telephone conference. Back on March 25th of 2020, an order went in place for the state of Idaho and all of its judicial system. There's a lot of different rules and safety measures being put in place in order to protect everyone. The paragraph that directly affects Lori is number 2, and it reads as follows. All civil trials, hearings, and motions should be postponed and rescheduled for a later date unless the assigned judge finds the proceedings can be held and adequately recorded through telephonic or video means and placed into the official court record. Any civil trial or hearing currently in progress shall be continued or completed at the discretion of the presiding judge. So based on this rule being put in place and knowing that Mallard has approved this motion to go before oral arguments, she is clearly confident that this can be held via a telephone or video conference with no problem. Like I said, I imagine that's what we're going to see Friday. It's just going to be up in the air whether or not we get to see it live or immediately upon its conclusion. And just today, after Judge Mallard decides, yep, we're going to take this to oral arguments, Justin Lum pops off with this tweet to confirm the following. Fremont County Prosecuting Attorney Marsha Murdoch asked Idaho Attorney General to take over investigation of Lori Vallow and Chad Daybell for conspiracy, attempted murder, and/or murder. Chad's first wife, Tammy, died on October 19th of 2019. The Daybell family home is located in Fremont County, Idaho. That will bring in a whole nother county and a whole nother jurisdiction and new faces into the crowd.
New tonight, Fox 10 has confirmed the Office of Idaho's Attorney General is taking over the case connected to the mother of 2 missing kids with Arizona connections. Lori Vallow and her husband, Chad Daybell, will be investigated for conspiracy and attempted murder. Fox 10's Justin Lum has been covering this story since day one. He joins us with this new information tonight. Justin.
Carrie, at the center of this case is Chad Daybell's first wife, Tammy, who died on October 19th. Her body was exhumed on December 11th. We are still waiting for her autopsy and toxicology reports. But my source confirms the Idaho Attorney General is now taking over this case due to having more resources, but it does not necessarily mean charges will be filed.
The reality is here now for those 2.
The grandparents of 7-year-old JJ Vallow, the boy who's been missing since September, along with his 17-year-old sister, Tylee Ryan, are hopeful investigators are combing through any case connected to the children's mother, Lori Vallow. One confirmed link being looked into is the death of Tammy Daybell, the first wife of Lori's husband, Chad.
The case is moving forward and it's not stagnant. I never thought it was, but I know there are numerous people working on it daily.
Letter obtained by East Idaho News from the Office of Idaho's Attorney General to the Fremont County Prosecutor says the AG will assume full responsibility for the case of Tammy Daybell's death. The request for help was made Tuesday and accepted Thursday. Chad and Lori got married a little more than 2 weeks after Tammy's death, then determined to be of natural cause. The death of Lori's former husband, Charles Vallow, is being investigated by Chandler police, who say Lori's brother shot and killed him in self-defense last July. Kay Woodcock says her brother Charles knew about his wife's relationship with Doomsday author Chad Daybell since last January.
Charles showed me several things that from his email that indicated that they were having an affair.
Meanwhile, Lori Vallow is in Madison County Jail on 2 counts of felony child abandonment. A hearing is set for April 17th as her attorney tries to reduce her $1 million bail amount.
I hope that it's left alone. The judge sees through this and does not reduce her bail. I think this is exactly the time not to be reducing bail.
We did reach out to the Attorney General spokesperson for more comment. We have not gotten a response yet. A family member of Tammy Daybell, who wants to remain anonymous, tells me the AG taking over this case is great news and hopes for resolution. Reporting live, Justin Lum, Fox 10 News.
Let's take a quick peek at the letter obtained by East Idaho News that Justin referred to in that news clip. It's in regards to the agreement on prosecutorial investigative assistance request. The requested date was the 7th of April and it was approved on the 9th. The nature of assistance requested is prosecutorial review. Name of defendant and matter. This is the good part. Chad Daybell, Lori Vallow Daybell for conspiracy, attempted murder, and murder. Dear Marcia, pursuant to the terms of paragraph A, 2B of the Memorandum of Understanding regarding prosecutorial assistance dated November 5, 2015, between the AG and the Idaho Prosecuting Attorneys Association, this letter of agreement is intended to memorialize our joint understandings regarding the request for assistance that the AG received from your office on the above case and matter. The nature and scope of the assistance required by the county in which the AG has agreed to provide are as follows: providing prosecutorial assistance due to other reasons without local prosecutor involvement. Scope of the assistance to be provided. Review and investigate incident reports, make the decision to file charges or decline prosecution, and handle the matter through final resolution in the trial court. The AG will assume full responsibility and authority for this case. All decisions regarding the case shall be the responsibility of the AG. The county prosecutor will file an appropriate motion under the provisions of Idaho Code 31 to allow the AG designee to appear in the case, or the AG will file a notice of appearance pursuant to Idaho Code 67. Payment of cost. In all cases, the county will pay the out-of-pocket expenses incurred by the AG's office. Out-of-pocket expenses include all costs for witnesses, expert witnesses, transcription services, subpoenas, any lodging expenses the AG's office incurs in the course of the case. All expenses for travel other than in-state vehicles, whether airfare or mileage reimbursement, and a per diem reimbursement for meals. The AG will pay the salaries of all AG personnel involved in providing the assistance. All payments made to the AG's office shall go through the business manager for the Office of the Attorney General. And page 3, sign here if you agree. Everybody sign, and this agreement has now been officially made. Now, just like Justin said in his news clip, just because the AG's office is investigating does not guarantee that charges are coming down the pipeline. It would be great if that guaranteed it. At this point, it just does not. So at this point, it's still a waiting game as far as all that is concerned. But just like I've always said with Lori Vallow, I would much rather them take their time, make sure they have all their ducks in a row, make sure that they're, there's no such thing as a slam dunk case, ever. But let's get all these ducks in a row. Let's make sure all the evidence is there, everything that they need to take Chad and Lori to trial, and all but guarantee a conviction. That's what I want to see. Patience is wearing thin, but time is definitely on our side. So we'll just take what we can get, and the fact that it is somewhat progressing, you always have to start somewhere, right? Let's take the AG's participation in the investigation as a win for us. So I hope wherever this video finds you, you guys are safe, you are healthy, you are having the best day ever. I hope you guys have enjoyed listening to Chad's blog entries. Today is Sunday, April 12th, and I uploaded episode 2 this morning. Now, episode 3 is going to go up on Monday, April 13th at around 11 a.m. I've also been working all day on recording the next 3 episodes, which should conclude that whole series. and we should have one of those every day throughout this week. So that will give us Monday through Thursday, and then Friday, of course, we'll be able to meet up here on this channel and talk about what goes down in court for this 4th bond reduction hearing. You guys stay safe, make good choices, and we'll talk very soon. Bye, guys.